Welcome to EUPrivacyForAll Session53 on GDPR, Archiving Article 83. For European Parliament, Article 83 key point was stressing that as far as data for identification of data subjects and other data would be kept separately under the highest technical standards, and all necessary measures would be taken to prevent unwarranted re-identification of the data subject, such a further processing for historical, statistical, scientific purposes would be allowed. It was also suggested that Article 83A would be created to frame the processing of personal data by archive services. On its side, EU Council stressed that Union or Member State law may, subject to appropriate safeguards for the rights and freedoms of the data subject, provide for derogations regarding data subjects' rights. Where personal data was to be processed for archiving purposes in the public interest, Union or Member State law may, subject to appropriate safeguards for the rights and freedoms of the data subject, provide for derogations, insofar as such derogation is necessary. The idea was to minimize the processing of personal data, notably using pseudonymization of data. In the final draft of Article 83, entitled Safeguards and Derogations for the Processing of Personal Data for Archiving Purposes in the Public Interest or Scientific and Historical Research Purposes or Statistical Purposes, the first paragraph lays down that appropriate safeguards for the rights and freedoms of the data subject should be provided. These safeguards shall ensure that technical and organizational measures are in place and ensure the respect of the principle of data minimization. These measures, beyond data minimization, may include pseudonymization, as long as those purposes can be fulfilled in this manner. One key point to stress is that whenever these purposes can be fulfilled by further processing of data which does not permit or not any longer permit the identification of data subjects, these purposes shall be fulfilled in this manner. De-identification is key for archiving purposes in the public interest, scientific, historical, or statistical purposes. Paragraph 2 and 3 of Article 83 distinguish two different situations. First, the purposes of scientific, historical, or statistical purposes that could provide derogations to certain data subjects' rights, and archiving purposes in the public interest that would grant additional potential derogations, that is to say, regarding notification to data subjects and recipients and portability right. The paragraph 4 of Article 83 stresses that where processing serves at the same time another purpose than the one of scientific, historical, statistical, or public interest, the derogations shall apply only to the processing for those purposes. A key recital in GDPR is recital 125. It makes clear that technical and organizational measures would ensure the principle of data minimization, as already stressed in Article 83, but also that the controller shall assess the feasibility to fulfill those purposes by processing data which does not permit or no longer permit the identification of the data subjects. That is to say that assessment by the controller is a key obligation. In the frame of archiving, some data subjects' rights might be restricted, such as the right to information, rectification, erasure, the right to be forgotten, restriction of processing, data portability, and right to object. some specific procedures could be defined and data subjects would have to exercise those rights differently. It is also stressed that those points and provisions do not apply to deceased persons. Member States should also be authorized to provide that personal data may be further processed, providing specific information related to political behavior in certain historical contexts. Recital 40 lays down that further processing shall be, in such a framing, considered as compatible, lawful processing operations. It is reminded in Article 5.1 on principles relating to personal data processing. Currently, Article 6.1 of the Directive on the Processing of Special Categories of Data lays down that purposes should be specified, explicit and legitimate, and no further processing should be handled in a way incompatible with the initial purposes defined for collecting data. As such, historical, statistical or scientific purposes shall not be considered as incompatible. Beyond that, the fact of keeping data in a form which permits identification of data subjects shall not be possible whenever it's not necessary anymore. Therefore, Member States shall lay down appropriate safeguards for personal data stored for longer periods for historical, statistical or scientific use. Let's notice that public interest is not mentioned. What should accountable data controllers and processors get prepared for? First, they should consider that whenever public interest, statistical, historical or scientific purposes are at stake, they should implement technical and organizational measures to meet the principle of data minimization. Among others, pseudonymization measures could be adopted. Second, they should bear in mind that data should not, as far as possible, permit the identification of data subjects. In the frame of scientific, historical or statistical purposes, Member States could provide derogations to the right of access, rectification, restriction and the right to object. Beyond that, in the frame of public interest purposes, Member States could provide derogations to the rights previously mentioned, plus the obligation to notify recipients and data portability right. In both cases, derogations to the rights of data subject should be possible only if those derogations are likely to render impossible or to seriously impair the achievement of those specific purposes, and such derogations are necessary for the fulfillment of these purposes. Finally, the regulation does not apply to the deceased persons. So the key question we've got in mind today is knowing whether the requirements on de-identification will be further specified.